And Czaplinski was the origin of the fighting words exception, an entire category of speech that doesn't have any First Amendment protection. And the court came out the way it did without any evidence that Czaplinski's speech had in fact caused any harm at all, or had even offended the city marshal, and you would expect that a law enforcement officer would have thicker skin than most. And then you've got judges deciding what's of sufficient social value in people's speech. But it would be fair to call Walter Czaplinski a First Amendment villain because the fighting words exception is attributable to him. It was the court's mistake, and it was a mistake that the court has been trying, not hard enough in my view, but trying to rectify ever since. The court has very narrowly limited Czaplinski at every opportunity. Never since 1942 has the court upheld a conviction for using fighting words. And the later cases have interpreted, as Cohen did, the Fuck the Draft case, have interpreted Czaplinski as requiring a direct tendency to cause violence by the person to whom the epithets are addressed face to face, not by an unruly crowd. You can upset an unruly crowd, and that's fine, but if you're one-on-one with somebody and about to provoke a breach of the peace, about to provoke violence, the court still thinks that the fighting words exception applies. And we'll look again at this whole idea of categorical exceptions to protected speech as we look at the Stevens case coming up in a few minutes, and at the violent video games case decided last summer, in both of which the government argued that the speech in question fell into a category of speech that didn't have any First Amendment protection at all. And then there's another Jehovah's Witnesses case in which they won, and with similar issues, a whole variety of dissidents and socialists and communists had lost their cases. As I said, the witnesses don't serve in the military at all. They're conscientious objectors. They urge those to whom they preach not to support war, and they did so during World War II. And 3 of the witnesses down in Mississippi were convicted under a brand new Mississippi law for disseminating literature that was calculated to encourage disloyalty to the national and state governments. And this was a felony under Mississippi law. And the witnesses, the 3 of them who'd been arrested in Mississippi, were sentenced to prison for the duration of the war. Their literature that they were passing out said that Satan influences public officials and others to compel little children to indulge in idolatrous practices by bowing down to some image or thing, such as saluting flags, in direct violation of God's commandment. And one of the witnesses, the evidence showed in speaking with several women, the sons of 2 of whom had been killed in action overseas, had offended them by declaring it was wrong for our president to send our boys across in uniform to fight our enemies. Well, there we are in the middle of the war and all of this patriotic fervor, and the Supreme Court decides quite summarily that that violated, the conviction violated the Jehovah's Witnesses' rights. There was no showing, the court said, that the witnesses had done anything with an evil or sinister purpose. They hadn't advocated or incited subversive action against the nation or the state, and they hadn't threatened any clear and present danger to our institutions. And this was one of the rare instances in our constitutional history in which the clear and present danger test actually resulted in freeing a subversive speaker. The test, as you've undoubtedly picked up, originated in Justice Oliver Wendell Holmes' famous opinion in Schenck versus United States in 1919. That was the court's first time, really, to consider the extent to which the First Amendment protects free speech, at least subversive speech, and the court's first significant decision under the First Amendment, 1919. Remember that the Sedition Act of 1798 never got to the court. It expired of its own force in 1801. Schenck was convicted under the World War I Espionage Act, which made it a crime to cause disloyalty or insubordination in the military forces. He had distributed leaflets, here they are, that exhorted the men who were subject to the military draft to assert your rights. The leaflet cited and discussed the 13th Amendment, saying that the draft was slavery. And the pamphlet, you probably can't see it, but it had such subversive advocacy as this. If you don't assert and support your rights, you're helping to deny or disparage rights, which is the solemn duty of all citizens and residents of the United States to retain. And it closed with, help us reestablish democracy in America. Remember, eternal vigilance is the price of liberty. That's Thomas Jefferson. Down with autocracy. Long live the Constitution of the United States. Long live the Republic. Schenck's literature says. Well, Justice Holmes wrote for a unanimous court that Schenck's speech was not protected by the First Amendment. And he prefaced the ruling by saying this, which I'm sure you've heard 1,000 times. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Well, that's self-evident, isn't it? And it's such a great metaphor. It's obviously got legs. It's been with us ever since. And it's just so inappropriate in this context. I mean, nobody's yelling fire in a theater here. It's political speech, exhorting people to exercise and test their constitutional rights. And to use that yelling fire in a theater metaphor in this context was, I think, a major mistake. But he goes on, in the course of the Schenck opinion, to announce what he and the court then adopted as the proper test for whether subversive speech could be punished. And that's whether the words create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. And the court determined that Schenk's speech did meet the clear and present danger case, created a clear and present danger that men might refuse the draft and not serve in the military. And during that same month of March 1919, Justice Holmes and the court unanimously upheld the conviction of Eugene Debs, who had long been the leader of the Socialist Party in America, a 5-time candidate for president of the United States, who made a speech that was mostly about socialism, but included complimenting some young men who had refused to register for the draft. And for that, Eugene Debs was sentenced to 10 years in prison, which he served. The court upheld Debs' conviction. Somehow, over that summer of 1919, Holmes changed his mind. Books have been written about how this happened, and there's really no completely satisfactory explanation. Maybe he realized how unthreatening this kind of speech really was. Anyway, in a case that came up in the fall of 1919, United States versus Abrams, the court affirmed another one of these subversive speech convictions. Holmes dissents, condemning this persecution for the expression of opinion. And he introduced in the Abrams opinion the whole marketplace of ideas concept that is now embedded in our First Amendment gestalt. That's probably not the right word, but you know what I mean. The best test of truth is the power of the thought to get itself accepted in the competition of the market. He says this is the theory of our First Amendment. It's an experiment, as all life is an experiment. And we have to be eternally vigilant against attempts to check the expression of opinions that we loathe and believe to be fraught with death. Well, the court continued, despite Justice Holmes' eloquent dissent, to affirm subversive speech cases like Gitlow and Benjamin Gitlow, the socialist in 1925, and all the way up to Stromberg in 1931, where the tide turned. And Holmes would frequently dissent in tandem with Justice Louis Brandeis, and they wrote this wonderful stuff. The Brandeis opinion in 1927 in Whitney versus California really is a catalog of the reasons why we support free speech in this country. That the framers of the Constitution believed that freedom to think as you will and to speak as you think is indispensable, and that the greatest menace to freedom is an inert people, saying that public discussion is a political duty of a citizen, and that we as citizens have not just the right, but the duty to speak out and criticize government and government officials, a notion that we'll encounter next week in the New York Times versus Sullivan case. And then decades later, up into the McCarthy era in the early 1950s, the court was still upholding convictions of communists, including Eugene Dennis, the head of the American Communist Party, finding that his and others' conspiracy to organize the party and, quote, advocate the overthrow of the United States government satisfied the clear and present danger test. And as interpreted in all of those subversive speech cases from Schenck through Dennis, the clear and present danger test was a paper tiger. It really did not protect subversive speech. That has been changed principally by the Brandenburg case that we'll consider week after next, Brandenburg versus Ohio, where it looks like the court has abandoned the clear and present danger test as the standard for deciding whether supposed subversives can be criminally prosecuted for what they write or they say. But what's kind of striking is that only the Jehovah's Witnesses in the Taylor case found freedom from the application of the clear and present danger test, while all of these communists, socialists, and others lost when the court applied it. The witnesses have continued to litigate their cases when they had to. They've got a squad of real good lawyers at their headquarters in Brooklyn and are ready, willing, and able to challenge the restrictions on the witnesses' activities. The last time they went to the court was in 2002 in the Village of Stratton case, which was another one of these door-to-door ordinances that required everyone in the little village to get permission of the mayor, to register with the mayor before conducting any door-to-door solicitation. And the witnesses, of course, objected to that. And the Supreme Court, in an opinion by Justice John Paul Stevens, said that that ordinance, like all the ones back in the 30s, was unconstitutional. You can't be required. A woman who wants to tell her neighbor to go down and vote for something in the upcoming election would have to go to the mayor first and get permission to ask her neighbor to vote. And the court struck down that ordinance as well. That's the last time the witnesses were there. So what do we owe to the Jehovah's Witnesses? No licensing of the press, the Lovell case. No need to get approval of government for distribution of newspapers, magazines, whatever. No compelled expression of patriotic belief. The right not to speak. The right not to be required to carry a government message with which you disagree. That's the license plate case. And some life in the clear and present danger case. And the big loser was the Chaplinsky case and the establishment of the fighting words doctrine. So that's an impressive catalog of First Amendment principles that the Jehovah's Witnesses have been responsible for. Stretch for a second. Let me retool here and we'll be back with animal cruelty. Well, you don't have to, actually. We can go right to it. The animal cruelty case, the Stevens case, where the speech is just disgusting. We have to have this depictions of animal cruelty. The law originated when Congress got upset about crush videos, which I'd never heard of until the case came out. But crush videos are apparently videos that are produced and sold that appeal to a certain sexual fetish. And people are sexually aroused by seeing a little animal like a mouse or a kitten or a bunny crushed, frequently under a stiletto heel like this, and killed. You can find them online. They're real, they make you squirm. And Congress squirmed, and Congress was very upset about crush videos. So, of course, they passed a law prohibiting the creation, sale, or possession for commercial purposes of certain depictions of animal cruelty. The law applied to any depiction of cruelty in which an animal is intentionally maimed, mutilated, tortured, wounded, or killed, it did exempt, and this is an important and interesting point, it exempted depictions with serious religious, political, scientific, educational, journalistic, historical, or artistic value. Violation of the law carried a prison term of 5 years. And when President Clinton signed the law, he instructed the Justice Department to prosecute only cases in which the depictions appealed to the prurient interest, the interest in sexual arousal, as is the case in obscenity. So here's one of our several visits to the law of obscenity. This is the way the Supreme Court finally settled on a definition of what is obscene and therefore unprotected. To be obscene, the materials have to meet all three tests. The material has to appeal to the prurient interest, has to be sexually titillating. It's second, the depictions of sexual acts, obscenity is about sex, of sexual acts has to be, quote, patently offensive as judged by contemporary community standards. And third, the material has to lack serious literary, artistic, political, or scientific value. And the provision by Congress in the animal cruelty law picks up the idea of this third part of the Miller versus California obscenity test. Well, Robert Stevens sold videos of pit bulls in dogfights and attacking other animals. The videos came from, either they were old, or they came from Japan, or other places where dogfighting is apparently legal. And some of them involve pit bulls hunting wild boar and killing a farm pig and so on. Not a crush video at all. No prurient interest involved. But Stevens was prosecuted during the George W. Bush administration. His Justice Department simply ignored President Clinton's instructions to the Justice Department. And they prosecuted Stevens. He's convicted and sentenced to 37 months in prison for grainy, lousy pictures of dogs fighting. And he appealed to the Supreme Court, which resulted in a very surprising opinion by Chief Justice John Roberts, who followed pretty conventional First Amendment analysis, finding that, and this is real familiar to us now, that the law is content-based. It prohibits a particular kind of speech, content of speech, animal cruelty depictions. And since it's content-based, it is presumptively invalid. And that means that the government has the burden of demonstrating a compelling interest for the restriction, and that the restriction is narrowly tailored to serve that interest. And the Chief Justice pointed out that, under this law, maiming, mutilating, and torturing may convey cruelty, but wounding and killing don't necessarily convey cruelty. I mean, think of all the ways and reasons for which animals may be killed, or wounded. Hunting, for example, which seems to be the one that the court zeroed in on most. And that doesn't necessarily involve cruelty. Then the court also referred to, in saying that the law was overbroad and not narrowly tailored to fit the Crush videos rationale, that bullfights, pictures of bullfights, rodeos, safaris, slaughterhouses, could all come under this law. And so the court held the law unconstitutional, a violation of the First Amendment, rejecting the government's argument that depictions of animal cruelty are a category of speech that has so little social value that it should be unprotected completely by the First Amendment, by analogy to Chaplinsky and the fighting words exception. The depictions of animal cruelty ought to be treated like obscenity, like child pornography, pictures of children doing sexual things, like libel, fraud, and fighting words. And the government proposed this simple balancing test that whether a category of speech enjoys protection depends on balancing its value, the value of the speech, against its social costs. And you would think that that notion would have some appeal to Chief Justice Roberts, but he rejected it resoundingly, saying this free-floating test for First Amendment coverage was startling and dangerous, and that the guarantee is not limited to categories of speech that survive some kind of ad hoc balancing of relative costs and benefits. He says that balance was struck by the First Amendment itself, in which the American people decided that the benefits of the restrictions on government outweighed the costs of citizen speech. Our Constitution forecloses any attempt to revise that judgment simply on the basis that some speech just isn't worth it. So the court has no freewheeling authority to declare new categories of speech outside the scope of the First Amendment. Sounds like that's the death knell of the whole categorical approach to First Amendment decision-making, that the court is not going to be open to deciding whether there are categories of speech that haven't historically been treated as unprotected, like obscenity and libel. And now fighting words, they keep putting fighting words in the list, but opening up new categories of unprotected speech seems